court's permission, I would like to reserve 10 minutes of my time for rebuttal.
You say 10 minutes?
Yes, Your Honor.
All right. Thank you.
Your Honor, may it please the court, in 1959, the United States Supreme Court held in Napu versus Illinois, the jury's estimate of the truthfulness and reliability of a given witness may well be determinative of guilt or innocence, and it is upon such subtle factors as the possible interest of the witness in testifying falsely that a defendant's life or liberty may depend. This is that case. Shaun Hodge has spent the past 20 years in prison due to the knowing perjury of the state's key witness, Patricia Hamilton. Ms. Hamilton knew she was testifying falsely. There's no mitigating circumstance, I think, that she could have been honestly mistaken as to whether or not she had a conviction for theft. She was asked that explicitly at the trial. She testified in the negative that she did not.
Did you say she'd been charged with perjury?
No, Your Honor. No, I'm saying that she committed perjury when she testified at the trial of this case. She's never been charged or convicted of that.
So did she testify a second time under oath contrary to that?
Well, Your Honor, the documents that we...
No, wait. You said she committed perjury, and I'm trying to figure out how that, you're making that determination or a judge has made it? Or?
I'm making it, Your Honor.
Oh, okay.
That's my argument, that she committed perjury based upon...
I thought you were saying she'd been convicted of perjury.
No, Your Honor, I am sorry if I said that I misspoke, or if I conveyed that rather. No. The facts of this case, I'm sure the courts has read the briefs, but in his coram nobis petition, my client attached judgments of conviction for theft for Ms. Hamilton. That judgment was the result of a bench trial that was held approximately 2 years before Mr. Hodge's trial. It arose from conduct from the charge itself, which was in March of 1998, and of course the shooting happened on April 26, 1998. So in March 1998, Ms. Hamilton was charged with theft. 2 years later, or a year later in 1999, she was convicted after a bench trial of that theft, and then in 2001 was Mr. Hodge's trial. She was asked point blank at the trial if she had a conviction for theft or any felony convictions that were more than 10 years old, and she answered no to both of those. Well, there's no way for her to have been mistaken about her theft conviction when she had just gone through a bench trial and when she had that conviction. So I think there's no question, at least in my mind, that this was knowing perjury by the state's witness, because she would certainly have known that she had been convicted of theft, and she would know that when she testified that she had not had such a conviction, that testimony was false. This was a trial that was a swearing contest between two opposing sets of witnesses. On the state side, there were 4 witnesses, including Ms. Hamilton. All of those witnesses were impeachable, but Ms. Hamilton was the least impeachable. The other witness, for instance, was Lorraine Young. Ms. Young's testimony was subject to impeachment because she told the police that she did not witness anything. Then at the trial, she pops up and she says, "No, I saw it all. In fact, Shaun Hodge came to my door." Well, both of those can't be true. Either she didn't see it and she was honest with the police, or she did see it and she was dishonest with the police.
Wasn't that an issue for the jury to decide?
Yes, absolutely. Absolutely.
They apparently believed her, or at least believed the proof had been told.
Yes. So I think the point is that at the trial, there was a reason for the jury to believe her, and there was a reason for the jury not to believe her. The other witness, for instance, was Tim Bolden. He was the alternate suspect in the crime. He testified that he had made a deal with the state, that he was testifying in part because he did not want to be blamed for the crime himself. There were defense witnesses who identified him as the perpetrator of the offense. The next witness was Deborah Turner. Ms. Turner was subject to impeachment because she had an axe to grind against Shaun Hodge because he had assaulted her son. And there were two defense witnesses who testified at the trial that Ms. Turner had told them that she was essentially going to frame Shaun Hodge in order to retaliate against him for the assault upon her son. And so that left Patricia Hamilton. And Ms. Hamilton, I would suggest, was the state's most credible witness because she stated that she was there to visit her cousin, Deborah Turner, and albeit Ms. Turner had an axe to grind, that doesn't necessarily mean that it was Patricia Hamilton's axe. She testified that she had a conviction for drugs, and the prosecutor made lengthy efforts during the direct itself to rehabilitate that conduct. The prosecutor asked her how she had done on probation. Ms. Hamilton stated she had done great on probation. The prosecutor asked her if she was a church-going lady, which around here is code for good person, and she said she was a church-going lady. And so the prosecutor minimized that theft conviction and painted Ms. Hamilton as a woman who had made a mistake, who was not a major criminal offender, and who had reformed and rehabilitated herself and learned her lesson. And Ms. Hamilton's testimony was absolutely devastating to Shaun Hodge because she testified she had known him her entire life, or his entire life. And she testified she looked out that window and she saw Shaun Hodge and she knew exactly who it was because of that relationship. And there was no bias beyond just the relationship with Deborah Turner on Ms. Hamilton. Ms. Hamilton testified she didn't come forward and tell the police because she was afraid of Shaun Hodge, and she was afraid of what Shaun Hodge would do to her, having just witnessed him commit a murder. All of that, Your Honor, is either false or subject to impeachment. And if the jury's verdict, and I think it did, because there were multiple defense witnesses, and I talked about one of them in our reply brief, but there were certainly others who said that Shaun Hodge was not the person who committed this murder. And I think that there is a more than reasonable probability that the witness who tipped the scales in favor of the state was Patricia Hamilton. And if the jury had known the truth of what was actually going on, that verdict could well have been different. Because in fact, the state's direct examination was, first of all, again, false testimony, but certainly also misleading and creating a misleading impression. It was not true that Ms. Hamilton had done great on probation. In fact, when she picked up the theft charges, she was still on probation for the drug offense. And she was under conditions of probation, which required her to abide by the law. And so being charged and convicted after a bench trial of a theft would violate her probation. That's certainly not someone who has reformed, who has turned over a new leaf. That is someone who has continued on a course of criminal conduct. But beyond that, and I cited Davis versus Alaska in our original brief, there are two types of impeachment evidence, especially when it comes to convictions. There's the type of impeachment evidence that says, this witness is dishonest. Don't believe this witness. And a felony conviction, I would argue, is slightly impeaching. Obviously, a crime of dishonesty, like theft, is more impeaching. But the second type of impeachment evidence is the motivations and bias of the witness, why they're there, the personalities and conduct involved. And what this theft conviction, I think, says, Your Honor, is that it raises two possibilities. And the one is that Ms. Hamilton did not come forward to talk to the police, not because she was afraid of Shaun Hodge, but because she wasn't there, because she had violated her probation and she was in jail in Georgia. And that, I'm sure the court is aware, if you violate your probation, generally what happens is that you get picked up and arrested and you're in jail. The second is that she was visiting Deborah Turner, not because she was there to innocently visit relatives, but because she was an absconder from probation. She knew that she had that pending theft charge, and so she was hiding out with Miss Turner in her house, and that's why she didn't come forward and talk to the police, because she knew she had this active theft case and a violation of probation. And that, I think, casts her testimony in a completely different light. It gives the jury a reason to believe that she wasn't there at all, and it gives the jury a reason to believe that she was not somebody who had reformed, that she was a part of a criminal element, and secondly, that she had more reason beyond just the fact of a relationship with Deborah Turner to be on Miss Turner's side, because Miss Turner was effectively hiding her out from the police. And I think that does cast her testimony in a fundamentally different light. And I think that if Mr. Hodge had had the opportunity to take that evidence and to cross-examine Ms. Hamilton the way he could have cross-examined her, had he had that, then that could have swayed the jury that there was not proof beyond a reasonable doubt, and to look at the defense witnesses differently. And so I think that the question in this case is, does Mr. Hodge at least deserve an evidentiary hearing on his petition? And I think that what the Supreme Court has said, and there are factors, but what the Supreme Court has emphasized is that the main concern is a balancing test between the interest of the state in finality and effectively the interest of the defendant in justice. And I would say that this case is different than the Supreme Court precedents, because none of those cases involved false testimony by a state witness. And I would argue that in this case, based upon decades of United States Supreme Court precedent, that there is another interest involved, and that is the interest in the fundamental integrity of the justice system, and that when a witness testifies falsely in a criminal trial on a material point, that strikes at the heart of the integrity of the system. And so I would argue that Mr. Hodge at least deserves a hearing on his claims. I think that this case is very much in line with the Workman case, which both sides talked about. But I think that it's a very factually analogous situation. In this case, Mr. Hodge had sought discovery of the criminal convictions of the state's witnesses. He was denied that discovery. In Workman, the defendant had sought a subpoena for the autopsy photographs and was denied that. In both cases, obviously, the autopsy photograph in Workman existed at the time of the trial. It had to. I mean, you can't photograph an autopsy, 20 years later.
Ms. Lewis,
Yes.
I think the red light means that you.
Oh, I'm sorry, Your Honor.
You're burning up your rebuttal time.
I'm sorry, Your Honor.
No, that's all right. You can use the time, but I just want you
Your
to know
Honor,
you won't have as much rebuttal left. Maybe 5 minutes left for rebuttal instead of 10 is where we are right now.
Yes, Your Honor. I am so sorry. I didn't realize that. I'll sit down with the courthouse questions.
It's all right. Excellent argument. General?
Good morning, Your Honors, and may it please the Court. My name is Alan Groves, and I'm here on behalf of the state of Tennessee. Mr. Hodge is serving a life sentence for the 1998 shooting death of Benny Bowling. We're here to ask this court to affirm the summary dismissal of the Coram Nobis petition because it was filed nearly 20 years late, and due process does not require tolling of the 1-year statute of limitations. There's 3 words that haven't been uttered yet this morning in this case: due process tolling. That's what this case is about. It's not about Brady. It's not about NAPU. We're not even at the merits of the Coram Nobis proceeding because the trial court summarily dismissed the petition as untimely. Defense counsel, maybe in the last 30 seconds there, mentioned that there are factors that the court has established to consider whether you're entitled to due process tolling. So I'm going to walk through those three factors that the court's identified. The first is that
Did the trial court consider all of these factors before summarily dismissing this petition?
Yes, Your Honor. There's a written order. It's a page and a half, 2 pages long, and it definitely walks through each of these three factors and makes good findings.
All right, go right ahead.
So the first factor is that the facts establishing the ground for relief are later arising. That is, they arose after the statute of limitations had begun to run. Here, the defendant admits that Ms. Hamilton's criminal history, her criminal records in Georgia, existed at the time of trial. They were available. They could have been discovered. They were, in fact, discovered by Mr. Hodge on his own accord some years later. And so there's no reason to say that this claim arose simply when he discovered the criminal records in 2011, I believe.
Let me, before you leave that point, so the way I understand it, 1998 murder, 2002 trial. In 2012, Mr. Hodge filed an error quorum nobis petition with the affidavit of Ms. Hamilton attached, recanting her testimony. Does a petition, I guess is all we have, explain why he didn't discover this criminal record either in 98 or 2002 or 2012?
There's nothing in the record that would suggest why he was not able to find these records before now.
Does he say why he was able to find it in 2022?
Yes, he says that he got the assistance of an outside group, Black Lives Matter, who took an interest in this case and apparently submitted a public records request in Georgia to get these publicly available records, which could have been done at the time of trial.
Did he explain what information he received that he provided to this group that led them to search for criminal records in Georgia? Does that make sense?
I don't think so, but I think it was known at the time of trial that Miss Hamilton lived in Georgia, and I believe the felony drug conviction was a Georgia conviction. I'll stand on the record on that, but I believe it was a Georgia conviction. So there was reason to believe. It's not like he should have been going and doing a 50-state survey looking for criminal convictions in every state, but if she had ties to Georgia, a reasonable investigation might lead to that state. And Your Honor, I think that goes to the second factor of the due process tolling analysis, that applying the statute of limitations here wouldn't have deprived him of a reasonable opportunity to present this claim. Because even if the court disagrees with our analysis on the later arising factor, at the very latest, Hodge should have determined that these convictions existed, or that the theft conviction existed at that first quorum nobis hearing in 2012, because Ms. Hamilton testified on his behalf. So he had every incentive to ask her for as much favorable testimony as possible at that hearing. And she had every incentive to provide and to be forthcoming about that if she had decided to try to get him relief at that stage. And that's been over 10 years ago. So it's simply not the case that applying the statute of limitations here would have deprived him of an opportunity to come forward with this type of evidence. And this is exactly the same type of claim that this court rejected in Smith versus State, which Judge Wiedemeyer authored in 2015. The claim there was that the petitioner discovered the criminal history of a state witness who he described as the primary witness of the prosecution, and the court said, no, that's not later arising evidence, and you weren't deprived of a reasonable opportunity to present the claim. In preparing for the oral argument, I also came across another similar case, Winkfield versus State, from 2019 that held the same thing. And so the last point I just want to make is that third factor, that to obtain due process tolling in a quorum nobis case, you have to come forward with new evidence that would tend to establish actual innocence. And as I mentioned, in the Clarity case, the state's taken the position that actual innocence means that it's more likely than not that no reasonable juror would have voted to convict at trial. And here, I think both sides agree, this is impeachment evidence. It's not DNA evidence, it's not fingerprint evidence that would establish that this petitioner did not commit the murder. It's impeachment evidence against one state witness in a trial where there were 4 witnesses that say that they saw the petitioner shoot the victim, and a trial where 6 defense witnesses testified to the contrary. And so it's not like the petitioner points to this Vasquez case, which does say that impeachment evidence can be relevant in a quorum nobis proceeding. Now, that case wasn't about due process tolling. It was about the merits of a quorum nobis case. But I take the point that in some cases, maybe impeachment evidence can arise to meet this standard. But it would have to be a case where, for instance, the state only had 1 witness at trial, and the defense called no witnesses and had no proof. And then you find some new evidence that called into question the credibility of that single evidence or that single witness on which the whole case rested. And that's just not this case at all. The jury was able to evaluate 3 other state witnesses' credibility, consider the credibility of the 6 other defense witnesses who testified, and Judge Holloway, as you mentioned, these were issues for the jury to resolve.
Let me ask you a question about something you just stated and make sure I understand it. So there were 4 witnesses who testified that they saw the defendant shoot the victim. And then you said there were 6 witnesses that testified to the contrary. I mean, that would be that they testified that these 4 witnesses didn't see Mr. Hodge shoot the victim. What did you mean by that?
What I meant was, and I forget the exact numbers, they're in my brief, but a few of the defense witnesses testified they saw this shooting happen, but they didn't think that the perpetrator was the petitioner.
Okay, but they didn't say these 4 witnesses were lying or they didn't see what they said they saw. That's not what they testified to.
I don't believe so. One witness said that one of the state's witnesses was actually the shooter, and then there was a couple of other witnesses that said that Miss Turner had privately confided to them that she was going to falsely accuse the petitioner. So I guess those 2 witnesses did testify that Miss Turner was lying, that she had it out for the petitioner because there was this pending assault charge involving her son and the petitioner. But otherwise, no, Your Honor. The other witnesses' credibility wasn't directly attacked, except for Miss Turner. And so because the defendant or the petitioner has not presented evidence of actual innocence, and because this claim did not arise after the statute of limitations began to run, and because applying the statute of limitations wouldn't deprive him of a reasonable opportunity to present his claims, due process tolling is not available for this petition, which was nearly 20 years late. I'll last just mention this Workman decision by the Tennessee Supreme Court. There was a little discussion about that, and the state acknowledges that the evidence presented in that case was an X-ray that apparently was taken at the time of trial, but it was clear in that case that the defendant had subpoenaed the medical examiner's office for that evidence and was denied access to those records. And I think that was probably important to the court's analysis when it's determining whether the claim was later arising or not. Here, there's no proof that Hodge reached out to Georgia and tried to get access to these records and was denied. That was something that he just never pursued. So I think Workman is distinguishable in that respect. If there are no further questions, we would respectfully ask the court to affirm the judgment of the Quorum Nobis Court.
Thank you, General. And Ms. Lewis, I think you've got 5 minutes of rebuttal.
Yes, Your Honor. First thing that I would say is that this case is not a case where Mr. Hodge simply sat on his rights. First of all, he had tried to discover this evidence through the discovery process. I think that's very similar to a subpoena. He was denied that by the trial court, denied discovery of the convictions of the state's witnesses. But I also think, Your Honor, that there is a long line of precedent that excuses a defendant from going out and looking for records where the defendant has been told they don't exist. And in this case, this witness testified at the trial that she did not have a theft conviction. The prosecutor had access to the NCIC. I'm assuming that's how the prosecutor knew of the drug conviction. There's a long line of precedent that public officials are presumed to discharge their duties, as well as a long line of precedent that witnesses are presumed to tell the truth. There was no reason for Mr. Hodge to believe that this witness had not been truthful about her criminal history. The state did not solicited testimony, first of all, that she had not violated her probation, and secondly, the state, when she testified she did not have a theft conviction, failed to correct that testimony. And she was under oath at the time and gave that statement. And so I think that to impose upon a defendant this kind of free-reaching verdict duty that we're going to investigate everything that a state witness says, I think that the precedents of the United States Supreme Court as well as of this court are contrary to that. And when there is an affirmative statement to the defendant, this doesn't exist, then I think the defendant is entitled to rely upon that. I would also say that there is a companion case to this case that we filed, and I wanted to make the court aware of that, because after I was retained on this case, I did, partly because that they were poorly copied, I sent investigators down to Georgia, and I was not able to obtain these records. And so I filed a petition to reopen the second, my client's original quorum nobis petition, based partly on that and based upon some other factors, and the court summarily denied that petition as well. And so that case is currently pending before the court, and it is still, the record is being prepared. So I did want to make the court aware of that, but I think that that's one reason that an evidentiary hearing is required. I would also, we've talked about the Workman case. In that case, I think another factor that the court looked at, and again, in applying this balancing test is that Workman obtained the autopsy photograph, the x-ray, and then waited 13 months to file his quorum nobis petition. And the Supreme Court still said that he was entitled to an evidentiary hearing. And I think that in this case, there's not a lot of explanation as to why he waited 13 months. Workman did. In this case, there is a sworn statement under oath by this witness that she did not have this criminal history. I think, the state has mentioned the quorum nobis petition that involved Ms. Hamilton, where she recanted her testimony. I think, and there's been this argument, well, he could have found it out then, and I would say, why? Unless she told him that, why, when she's going to testify for him and her credibility is at stake, why would he ask her, did you lie under oath at the trial? I would argue that he wouldn't have a reason to do that, that she lied about her criminal history at the trial, because, the trial court in that second quorum nobis petition found her not to be credible in her recantation, and that's why he was denied there. But what I would also argue is, is that you have a witness who has recanted her testimony, who has previously done that and said, I was not truthful. And now we get evidence, I think, that directly supports the credibility of that recantation, that she wasn't truthful either because she wasn't in Tennessee, because she was in jail in Georgia, or because she was motivated to lie for Deborah Turner because she owed Miss Turner for hiding her out. And I think that when you put this case together with that previous quorum nobis petition and that recantation of the witness's testimony, it is fundamentally a balancing test. And all we're asking the court for is an opportunity to be heard and to present the case to the trial court in an evidentiary hearing. I mean, this man is going to spend the rest of his life in prison. And I think there is no question, and they haven't disputed this, that this was knowingly false testimony at that trial. And I think for that reason alone, the balance favors granting Mr. Hodge a hearing and allowing him to be heard.
All right, thank you, Ms. Lewis. Call the next case, please.